Welcome to this week's OK at Work with myself, Sarah Sawyer, and my colleague, Russell Berger from the Offit Kurman Labor and Employment Group. And this week, we are talking about the Time to Care Act of 2022 here in Maryland. That's the Maryland paid leave law that just passed as a result of the most recent legislative session, which just ended a week or two ago. And it is a paid leave law that will be going into effect kind of staggered. We've got the paid leave tax. Tax will start happening in 2023. The benefit itself will start in 2025. What are we looking at here with this law?
So what we're dealing with here, and I'll address this by using a comparison to another law that we're probably more familiar with, it's really functions in a way that's similar to me to unemployment. This has been versions of this law have already been implemented in other states and are already operational. But the way this basically works is employers with 15 or more employees pay a payroll tax into the state. Employees pay a tax into the state. So these are payroll withholdings. It goes into the state, and the state creates a fund. And when someone has a claim, just like unemployment, the state adjudicates it and pays the claim. So I think it's going to function similar to unemployment. Obviously, the triggers and the contribution amounts are going to be different and calculated differently. But as a starting point, the date for contributions beginning, I believe, is June 1st of 2023. And then I don't think anyone's eligible to take benefits until 2025, because obviously, given the system, money has to be paid in first to kind of fill the bank so that leave can be paid when someone takes it. So that's just kind of a basic starting point for what the law is going to look like or how it's going to function.
Yeah, and it's going to apply to employers with 15 or more employees. So that's also where the line is going to be, and also self-employed individuals can participate as well. Definitely, in looking at this law, it's definitely following the model of, there's other states that have similar laws. I know we've seen something similar in New York. New Jersey has something similar. So it's definitely following a trend that other, for some employers in Maryland that, might have out-of-state employees. I know we have some clients that are here in Maryland or in New Jersey, New York. I know our firm is in New York and stuff as well. So it's definitely following a similar pattern. Obviously, there'll be some uniqueness to this law, some differences, but definitely looks very similar to what some employers might be seeing in other states. And the leave itself will be used for employees who need to take leave to care for a newborn child, or one that's been placed for adoption, foster care, kinship care, to care for a family member with a serious health condition, to attend to their own, to an employee's own serious health condition, care for a next of kin service member, and then also there's if there's a qualifying exigency arising out of a family member's deployment. So, don't expect everyone to remember that just by watching this video, but those are the general reasons that people will be able to take leave. And similar to FMLA, there's also some requirements as far as how long an employee, how many hours the employee has worked over the 12 months immediately before they ask to take leave. They're going to have worked at least 680 hours. So there'll be some rules in there that look kind of similar to some other laws that employers already have to abide by. But this just like every law and every act, they all have their own little tweaks to them and uniqueness. So definitely something that employers will need to be paying attention to.
Yeah. I mean, in some ways, and this isn't a perfect comparison, but it's helpful to think about it as kind of creating a bucket of compensation for people who are going out on the leave items you enumerated. But it's really kind of akin to FMLA reasons for leave. Now, the Maryland law applies to a lot more employees and a lot in smaller employers than the FMLA. But it's creating a bucket of compensation. That's akin to FMLA leave. And the last point I wanted to make on it for now is just kind of what an employee gets. Obviously, this is less than critical for an employer because you're just going to pay the taxes, and you're not going to have to necessarily pay out. But the law provides for wage replacement up to 90% of the employee's average weekly wages, with a maximum weekly benefit of $1,000. So why this might be relevant to employers, and again, this is a decision to be made, um, you know, going forward, is you can create your own policy, and it gives you some wiggle room with how you handle the state aspect of it. And in many cases, you may already have your own policy. If you've got a paid parental leave policy already in place, you're now going to have to figure out how to wrap your paid parental leave policy around this pay, and how that, and you're gonna have to deal with the interplay of those two.
Good news here too is that we do have some time. So with some laws, especially during COVID, things were moving very fast, and employers really had to adapt quickly. I know we saw that with sick leave when it came out several years ago, but this is definitely there's some lead time here for employers to start to get familiar with the law, start thinking about those things, and figuring out how it's going to change their policies, and start preparing for those changes and integrating this into their policy manuals and things like that. So we've got some time here, which is good for employers, but it's coming. So definitely need something to pay attention to.
Yep, that's right. Always good to plan ahead and start thinking now.
Yeah. Well, thanks, Russell. We'll see you next time.
Thanks, Sarah.